Hi, everyone. This is Esther Kane with SeniorSafetyAdvice.com, and today we have a great interview for you with attorney Robert Bernstein. Thank you so much, Mr. Bernstein, for giving us the time to do this interview.
Oh, my pleasure.
Well, I'm very grateful for it. Just to give you a little tidbit on Mr. Bernstein, he's an attorney practicing in the state of New Jersey and New York. He's been practicing for well over 25 years, specializes in elder law, trust and estates, probate administration, and special needs planning for children and adults with disabilities, which is really, must be so fulfilling, actually. His main office is in Parsippany, New Jersey. He has satellite offices, though, throughout northern New Jersey and in New York City. He's a former deputy attorney general for the state of New Jersey, where he represented the Division of Taxation. He lectures throughout the state on issues of elder law, trust and estate, as well as special needs planning. Now, all this information, along with a link to his website, is going to be listed in the video in the description below. But welcome, Mr. Bernstein. Thank you again.
Thank you.
This interview is going to be one of actually several, because as we were discussing the issues that we were going to do in the interview, it kept expanding. There was so much information.
Yes.
So we thought, well, instead of doing a 5-hour interview, let's break them down into several. So in this particular one, we're going to talk about wills and trusts. And then in future interviews, we'll talk more about power of attorney, healthcare proxies, and then living wills, and any other issues that come up as far as legal documents and aging. And this is really information that, I personally feel that all older adults and their adult children should be aware of and work with. I know it's a difficult conversation to have for some families with their loved ones, when you're talking about wills and living wills.
It's important, but you know what? I hope that the myth that, if I do the will, I'm going to die soon. I'll tell you, my grandmother did her first will when she was 88 years old. And changed it 3 times on me. And she lived to about 94. And so it's like a puzzle, and it's something that you should have. It will provide you with a lot of security.
Yeah.
What happens often is people come to me, oh, we're going on a vacation, we're going to fly, and we're afraid, we haven't taken care of the kids, or they're on the plane already, and they say, oh, we never did our wills. You don't want to do it while you're in the hospital.
Right.
You want to recover from whatever it is that is ailing you. So it's good to do it while you're feeling well. You can think about these things. It's not snap decisions. As you'll see, there are a lot of different things to consider when preparing a will, and it should really be thought out carefully. So anyway.
It's true. I agree. So why do I need a will? Does everyone need a will? It sounds like it. Yes.
Yeah, if you're over 18 and you have assets in your name, you need a will. I'll give you an example of a sad story. This gentleman had remarried and was married to his new wife for 3 months. And he had children from prior marriage, and they were about ready to go to college about a year later, and the other one maybe 2 years after that. Well, he told his brothers, look, if anything happens to me, I want to make sure this money that I have is for my kids' college. This is a new marriage that I'm entering into, and hopefully it's going to go very well. But, I'm more concerned with my children right now. I'll take care of my new wife later. Well, as fate would have it, he went abroad on a business trip and he died suddenly, had a massive heart attack in his hotel room.
Mm.
And he hadn't done his will. He had tried to go online, it was confusing, and he never got it done. But when he died, there was no will. Well, what happens when there's no will is the state makes up the will for you. And I say they make up the will. It's called the laws of intestacy. There are laws that say if there's no will, this is who inherits. Well, under the laws, the second wife, who he was only married to for 3 months, got 50% of his probate estate, which is the last thing he wanted. His children didn't get all of the money that he had wanted to leave them. And I'm not certain. I think they might have had to take out some loans when they went into college, all because he didn't do a will. And by the way, this man was in his 50s. He wasn't in his 80s, okay, or 90s. There is no age limit or age requirement. You should want, especially if you have a child, whether it's a newborn
Agree.
Or a child that's 28, you should have a will.
I agree. I know many families that have children of all ages, and they do not have a will. And
Yes.
I think you're right. It is this misconception that, oh, if I write a will, it means I'm going to die soon, as if they're putting it out there in the universe or something. But it's not the case.
Yeah, quite to the contrary. Most of my clients, when it comes to signing the will and so on, say, this is such a relief.
Yes.
Been thinking about this for years. We've had it on the back burner. We're so glad to get it done with. And now you can put it away and go on with your lives.
Right.
And as I said, I tell clients, look, every 5 years, you should revisit it because things change.
Right.
So there are marriages, there are divorces, executors may have moved away. It's a living document, and you should update it from time to time, not every year, but 5 years or so, look at it. Maybe it's fine the way it is. Maybe the tax laws have changed, and your doesn't conform to the new tax laws. That's another thing that people don't realize is that wills will actually affect how your assets are taxed. And of course, it varies from state to state. And there is a federal tax, the U.S. estate tax. It's a death tax, which is payable when someone dies. Now, the exemptions vary and have been changing like the seasons. 1 year it's years ago it was 250,000. This year it's 11 million. Is it going to stay? They go back and forth, and you need to keep current to make certain that your estate's going to be protected from those assets, from those taxes, to the best that you can.
That makes great sense. I mean, but do wills get outdated? If someone picks up a will, I mean, if a client came to you and brought you a will that was written 40 years ago, is it still valid? Is it still legal?
That's a good question. If it was executed properly, it is still valid. But I'll tell you another horror story that client's wife died, and they had done wills at least 20 or 25 years earlier. Now, the wills were still valid, but the tax laws had changed. They had gone to a very prominent firm who had done a very good job in making a very sophisticated estate plan wills for them. But because it wasn't updated, the husbands wound up paying on his wife's estate over $400,000. If the bill had been updated, they would have paid zero. Imagine, between zero and $400,000, all because they never updated their wills. Now, look, obviously these people were well-to-do, but what if it was $40,000
Right.
that you had to pay unnecessarily? How long did it take you to accumulate, to save that kind of money? And if you had the ability to give it to your children as opposed to giving it to, whether it's the state of New Jersey or the US Treasury, wouldn't you want to take advantage of that?
Right.
So,
Right.
So that's the problem in failing to update your wills. And we come across wills where people are named that are deceased, or marriages where the deceased husband had named the first wife, who he wasn't married to for the last 20 years, and the will says it goes to her. Now there are laws which correct that situation, but it's time consuming. You have to hire attorneys to work that out. It's expensive.
Right.
If you had just revised your will, you could have saved that time, money, and aggravation. You know, it's an emotional time when someone passes away.
Right. And just to add that layer to it, on top of it, it's unnecessary. It truly is unnecessary. And you know, my viewpoint is, if you love your loved ones that you're going to leave behind, you would do as much as you can for them to make that transition as easy as possible. You know, anything
Yes,
you can.
yes. And there are other reasons for changing your wills. Maybe your daughter is in a poor marriage. You know, when they first got married, everything was glowing and so on.
Yeah.
Now you're concerned that if she inherits this money, will it wind up on the divorce table? You know, so there are ways of dealing with that issue. And just with our society being so mobile, as I say, executors moving away, or I had a situation recently where they'd named a spouse. The spouse was already deceased, but fortunately they'd named an alternate. But the alternate had very serious health issues and couldn't act. So now there was nobody to act. You need to update these things. Don't, you know, as I said, look at it as a puzzle.
Right.
Things change, you have to move around the pieces. And the more you plan, the easier it will be for your loved ones.
Right.
When something happens.
I agree. And I agree. And as someone who, you know, when my husband passed away, I mean, the paperwork and all that technical whatever that happens afterwards, it's not fun going through that, on top of all the emotional upheaval that is happening. I do strongly recommend. I tell all my friends to get their legal matters in order and everything else. But on a will, I mean, what should I include in the will? What should I not include? Or is there anything that I don't include in a will? Because I guess I can put anything in there.
Well, there are things which you don't need to include and which can be confusing. For example, a life insurance policy
Okay.
have a designated beneficiary. Now, if I said in my will, I leave everything to my wonderful wife, and in the insurance policy, I list the 20-year-old bimbo as the beneficiary.
Okay.
Well, when the will is probated, it's the bimbo will get the insurance policy because the designated beneficiary of a life insurance policy supersedes anything you put in a will. And a lot of people don't realize that.
Oh.
Designated beneficiaries such as IRA policies, IRA accounts, 401ks, pensions, they go by the designated beneficiary. And so one of the things that I do when a client comes in to me is I want to know what assets they have and who were their beneficiary designations. Because usually they had put that name down so long ago, they don't remember. Maybe you've named your spouse and one child, and since then you've had two more children.
Yeah.
They're going to be left out if
Yeah.
you don't update that. So when we say estate planning, we're not only talking about wills, but we're talking about your assets and how they're titled. And we want to coordinate that with the will. So, as I said, a life insurance policy should not be mentioned in a will. It's unnecessary. Okay.
Okay.
On the other hand, joint accounts will not go by the terms of a will. So if
Oh.
I have my daughter named on an account with me, my investment account, and it's in my name and her name because if I become ill, I want her to be able to manage my affairs. Well, and if I say in my will, I want everything divided equally between my son and my daughter. Well, that account that has her name on it is hers. Even it was joint with me, and once I die, it goes to her. Now, it's up to her as to what she's going to do, because by law, it's all hers. Okay. And the other problem is, let's say that she's very good natured and she wants to give 50% to my son, her brother. Well, if she gives it to him, she's going to be liable for a gift tax because it's now her asset and she's gifting 50%, even though she knows that was my wish.
Yeah.
Because of the way that the asset was titled, creates certain problems. So again, when you sit down with the attorney, we look at how these assets are titled and we make recommendations so that the client's wishes will be carried out. So in my example, instead of naming the daughter, my daughter, I would just leave it in my name. If I want someone to manage my account if I become ill, that's what a power of attorney is for.
Okay.
And so I would do something like that. So there are ways of having someone manage, whether it's your health or your finances, but you want to be careful about designating payable on death, in trust for, and so on. It can create real problems. Another problem while I'm talking about joint accounts is I had an estate where dad was a widower, and he had a house and he had $300,000 in bank accounts and 3 children. And some neighbor said to him, "Oh, you don't need to do anything with your will. What you should do is make 3 separate accounts, each of $100,000, and put a different child's name on each account. And that's what he did. But life got in the way. See, Dad got a stroke and he had to go into an assisted living. Well, the good daughter, we'll call her Sweet Sue, okay, came to his rescue and said, Dad, we've got this account. You've made this account, which is in my name and your name. I'll take it out of that account and pay for your time at the assisted living. And that's what she did. And when Dad died, there was $10,000 left in her account, okay? The other two accounts of her sister had 100,000 in each. So I'm going to ask you, Esther, and I'll ask your viewers, how many people think that the brother and sister said, oh, Sue, you spent all that money on Dad. We'll give you our proportionate share from our account.
I would like to say they did that, but it doesn't sound like it.
They didn't do it. And listen, it wasn't that they were evil and so on. The sister, okay, had been planning to remodel her kitchen. And as soon as Dad died, she went out, got the contractor, and she remodeled the kitchen. She got a new car. And the brother, his son Jason, was going to medical school, and he sent off the check from that account to pay off the tuition. So Sue had only $10,000, whereas they each had $100,000. But worse than that, what people don't realize is there are bills and things that have to be paid when you're probating an estate.
Right.
So there are filing fees with the surrogate, and maybe that house, he had a house. Where does the payment for the property taxes come?
Right.
Don't sell the house overnight. And they had to empty it out and so on. It took a couple of months. Well, there are property taxes. Dad didn't die April 16th or January 1. He died in the middle of the year. There were income taxes that needed to be paid. I don't know whether there was a car loan. There were debts, normal debts, not credit card debts that had to be paid. And Sweet Sue had no money to pay it. So she and her husband went into their personal savings to shell out money, pay for the dad's debts, including the house. The house was leaking. The air conditioning was on the fritz. And if in order to sell a house these days, people come in and they say, well, I want that repaired. I want the sidewalk is crumbling. It was okay for Dad, but when a buyer comes in, they want it just so.
Right.
So this Sweet Sue and her husband had to pull out a lot of money. Now, if he hadn't put their names on those accounts and just had $300,000 in his name, when he died, I didn't mention Sweet Sue was the executor. She would have paid all of the expenses from his money, and then what was left would be evenly divided between everybody. And that's what Dad had wanted. He didn't realize it would work out that way. He didn't realize the problem he was doing by making the joint accounts.
Right. Wasn't intentional.
No. He thought, that sounded perfect.
Sure.
Got 3 kids. He'll have 3 separate accounts, and it'll avoid probate. They can go right to the bank and draw out the money. Oh, yeah, they did.
They did right away.
Right away. I mean, he wasn't even cold, as they say.
If that isn't a cautionary tale, I don't know what is. I mean, but it does go to show that even if the dynamics in the family are good, anything can happen. These kinds of events can happen. So you do want to be as cautious as you can And a will can definitely, it sounds as if the will can definitely protect.
Yes, and again, and that's where the attorney comes in, is that the attorney can advise you of possible problems. And also, you want to speak with an attorney that you trust and have confidence in, and you can tell them, listen, my son has an addiction.
Yeah.
My daughter has an emotional problem and spends money like it was water. Uh, so the attorney learns things and then can advise the client, well, this this spendthrift that your daughter is a spendthrift, we can set up something for her, a trust, so that she gets the money, but she's not able to go through it immediately. That first conference is really uh, an informational one. I'm trying to get information from the clients, and I'm educating them as to what is out there. I'll tell you a story. I was speaking with an elderly woman. I was telling her about setting up what I call a Spendthrift Trust, where you can give it to the child in stages. Typically, this comes up where, let's say you've got $1 million policy at work. It's a term policy, it's worth nothing to you.
Right.
But when you die, someone, and let's say in this example, the kids, are going to get $1 million. Well, let's say you have two kids and they're 19 and 21. Do you want them coming into a check for $500,000?
Right.
Maybe not.
Right.
Well, there are ways in the will that you can set it up so they get it in stages. So I was telling this to this elderly woman, and she said, "Oh, that's a brilliant idea. This is just what I need." I said, "So when do you want it distributed to the children?" And so I was figuring she's going to say 25, 30, and 35 or something like that. And she said to me, 65.
She wants it to be their retirement.
Well, exactly. And she said to me, she said,
Wow.
"Robert, my son is 50 years of age and he hasn't saved a dime in his life. And I want this to be there for when he retires." So it really was a brilliant idea. And that's where I feel we as attorneys come in. See, I told her what was available.
Yeah.
And she crafted it so that it would fit her particular situation.
Right.
I had laughed at first, but then when she mentioned about the problems with her son, it made a lot of sense.
That's true. That's true. I mean, I love the idea that you can really customize it,
Yes.
to your own specific situation and needs and everything. So you were talking about, it sounds as if it is so important, and I think more beneficial to use an attorney versus like nowadays you can go online and create a will. So
Yes.
you won't have the benefit of the attorney talking to you like you were saying.
Yes. The benefit that you get by utilizing an attorney is the experience, the advice that the attorney provides you. And it is important. I've seen online wills. I came across a case. A husband brought his wife's will to me. Now, his wife had been a professor. I think she was an English professor,
Mm-hmm.
college, and she had decided, what the hell does she need an attorney for and to pay an attorney's fee? She was going to do it on her own. She was an educated person. And she did a will, and see, they had no children. And he had his own accounts, the husband, and the wife had her own accounts. And she made up the will that she was going to leave 50% to him. But the other 50%, she had about 20 different bequests. She had these nieces and nephews who she was very close with, and she wanted to leave something to the college so that they would put up a plaque in her name. She was president of the Garden Society. She was very active in her church, and she named all of these different organizations and nieces and nephews in her will. And she told everybody that she was leaving them money. And so she told her nephew, I'm leaving you $50,000. Nephew, oh my God. Well, when she passes away, we'll be able to buy a house. And she told the church and so on and so forth. And she figured that, when she died, probably a year later, they would be a memorial service for her. Well, she did an online will. And the husband brought it to me, and I looked at it, and I realized it was invalid. It wasn't good. But being an attorney, an adversary, I'm working on behalf of the estate. We brought the will to the surrogate and offered it for probate. And as I knew, the surrogate refused to probate the will. So the will was worthless. Now, remember I told you in that first case, what happens when there's no will?
Right.
The will is invalid. It's the same thing. Well, the state writes the will. And in this case, the state said everything goes to the husband. The entire amount in her estate. And by the way, she had close to $1 million.
Wow.
It went to the husband, and it bothered me. I never met the woman. As I said, I hadn't done the will. She did it online. But I just felt badly for her because you could see she put a lot of time and effort into all of these different bequests that she had. Well, so I called the husband into the office. And we went through many, many months of this. It was not an easy situation. And I said to the husband, I've got an idea. Why don't you do a will and say 50% is going to go to whomever you want, your family, and the other 50%, which is actually the money that you inherited from your wife, why don't you list all of those people, those institutions that she had in her will? Well, I thought I had just made a great recommendation. And he broke my arm, patting myself on the back. I thought that's a perfect way to resolve a sad situation.
Yeah.
And the husband said to me, Mr. Bernstein, those aren't my nieces and nephews. A professor in that college. I wasn't president of the garden club.
Oh,
Nothing.
no. That was that.
And that's because she did an online will.
Now, why was the online will invalid? I mean, what invalidated it?
I don't recall exactly. I think what happened in that case is that people had moved, and she crossed out the old address and put the new address in. If you mark up a will at all, dates it. That was the situation there.
Oh, and that was such a simple.
There's a lot of hocus pocus about a will. Or for instance, I've seen situations where, it needs to be witnessed. Well, her friend Mary wasn't available, but George was, so she signed the will in front of George. And then Mary, the next day, she says, here, Mary, sign as a witness. And then Mary is put on the stand and said, Mary, did you see her sign this will? Well, no, I signed it the day after. Invalid, not good. There are a lot of procedures
Right.
you need to follow when doing a will. Why take a chance?
Right.
Think of all of your assets which are at risk, the house, the bank account, the investment accounts. Isn't it worth it to invest some money and see a professional that makes sure it's done right, it's done
Right.
properly? So as I and these online, do you think? Well, we'll talk later about the trust for the spendthrift son, or the daughter who has a poor marriage. You're not going to find that in an online will. Maybe you don't need it, but there may be other things that you need.
Right.
And
And
let's say,
go ahead.
sorry,
Go ahead.
let's say that you have a son who is a broker on Wall Street, making money hand over fist, and your other son is an English teacher. And unfortunately, in this country, teachers are not paid what they are truly worth. And so maybe your feeling is, you know what? I'd like to give 3/4 of my estate to the son who's the teacher. I'll leave something to the other son, but he doesn't really need it. It's not lack of affection, but I want to, there are different reasons
Yeah.
that you don't have these cookie cutter type wills.
Right. And that is the great benefit of speaking to an attorney, because one, you have the history of all these stories and events that have happened. So you know all the different spokes that in the wheel of how this could go. And then because of that, you can ask the questions that will prompt your client, say, oh yeah, I didn't think about that, or, I didn't think this could happen or that could happen, but
Or that's a great idea that will fit my situation.
Exactly.
Look, we live in the age of specialization. And I don't do matrimonial law. I don't do bankruptcy law. When you go to see an attorney, you want to see an attorney that specializes in estate planning,
Mm-hmm.
and or probating estates and so on, because any kid out of law school can draw up a will, but will it have the type of things that you need based upon that specialization? So I don't think so.
Yeah.
So I would recommend that when you see an attorney, look, if you in an auto accident, you want to see a personal injury attorney.
Right.
Buying or selling a house, see a real estate attorney. But if you're doing a will or other estate documents, you should see someone who specializes in it, who knows the different problems that may occur and how to avoid them.
Right. Now, before you talked about trusts. Now, when
Yes.
I think of when someone talks to me about a trust or mentions that word, I immediately think, well, that's like for very rich people, for very wealthy people. Like, does everyone need a trust, or what is a trust?
Okay. Well, firstly, everyone does not need a trust.
Okay.
It depends upon the situation. So in answer to your question, what is a trust? It's a document, a written document
Okay.
that says whatever is in the trust is going to go this way, a certain way. And in many situations, it's similar to a will. But for example, let's say you have a vacation home in Florida, in Vermont, whatever. And typically what I have found is that most people want the vacation home to remain intact for the family.
Okay.
They've been going there every summer, every winter with the kids. The kids love it, and they want the kids to have it when they pass away. Whereas the house, they may sell. They all have their own houses, so that would be a reason to put the house into a trust, so that you can say it's going to go from generation to generation, if that's what you want. And there are two types of trusts. There's one called a revocable trust, which means you can change or amend it at any time.
Okay.
And there's something called an irrevocable trust, where once you put that asset in there, you can never get it and you lose control of it.
Why would anybody want that one?
Well, if you are very wealthy and you say, listen, I don't want my estate to be taxed on this asset when I pass away, so I'm going to give it away. But you know what? I don't want to give it to my son right now. I want to put it in trust. I want to make sure that it stays there. So that would be one reason. A life insurance policy. Let's say that you have a term life insurance policy for $500,000. What good is it to you?
Right.
It's worthless.
Right.
Because there are no dividends, okay? You can't borrow against it. It's just a piece of paper that says when you die, whoever you've designated, let's say it's the children, are going to get $500,000. But if you own it under the federal law, the U.S. estate tax, that will be considered an asset in your estate. Even though you couldn't spend it, it was worthless to you, your estate now is $500,000 larger because you owned that life insurance policy. If you put that life insurance policy into an irrevocable trust, okay, you're giving it away, but what are you giving away? Nothing.
Yeah.
When you die, that money is going to go into that trust. And the trust says how it's to be distributed. It's going to go to my children, to my wife and my children, whatever.
Mm-hmm.
So that would be a reason for using an irrevocable trust. Sometimes for tax saving, sometimes for an asset such as it's going to increase the size of your estate, but it's worthless to you while you are alive.
Mm-hmm.
So the more common, well, at least in my practice, is the revocable trust.
Yeah.
And so let's say, well, first of all, another irrevocable trust I forgot to mention. Let's say you have a child who has a disability and you want to make certain
Right.
that they're going to get that money. Maybe you're going to put a life insurance policy into that special needs trust or supplemental needs trust. And the trust says how the money is to be spent for that child. So again, rather than have the policy in your name subject to possibly being taxed, you're going to put it into this special needs trust. On another, we talked about vacation homes. Well, let's say I buy a condo in Florida.
Mm-hmm.
If you have an out-of-state property,
Mm-hmm.
in other words, I live in New Jersey and I have a condo in Florida,
Mm-hmm.
there have to be two probates when you die. One in New Jersey and one in Florida, because you've got an asset in the state of Florida and they require that. So you're going to have hire a Florida attorney. You're going to have to go into court. You're going to put all this probate double almost double the expense. If that Florida property, that condo, I put into a trust, it doesn't need to be probated. So I've saved the cost of a second probate by setting up a revocable trust that's for the property in Florida.
I see.
And you say to me, but wait a minute, Bob, what if you decide you don't like Florida and you want to move? It's a revocable trust. You can pull the property out, put a different property in, you can sell it, you can mortgage your property. You have every right of ownership as if it was in your own name.
Okay.
You've created this shell around it to protect it from probate, from a second probate. And as I said, not all probates are bad. Probate in New Jersey, it's really pretty simple and straightforward. But why do it twice? And
Sure.
turns out in Florida, the example I've given you, probate can be very difficult. It's much more time consuming than it is in New Jersey, and can cause a great deal not only of time but of expense as well.
So is that the main purpose of building a trust or putting your
There are
assets?
different reasons. Let's say that you have a child who is a spendthrift.
Mm-hmm.
And you can create what we call a testamentary trust, a trust within the will that says, look, the law in New Jersey, when you reach age 18, you are considered an adult. You have the right to inherit. But my son, Jonathan, I don't want him to inherit at age 18. He'll join some rock band and so on and so forth. And I want to see that this is held for him,
Yeah.
utilized for his college, and maybe any graduate school, or maybe when he's older to purchase a house. So you put that money into a trust for him. Or as I told you, I don't know why I choose female, the daughter with a bad marriage.
Yeah.
And you're concerned that, down the road, a year or two from now, or 3 or 4, they may wind up getting divorced.
Mm-hmm.
And you don't want that son-in-law to get his hands on any of this money. So putting it into a trust, showing that this was inherited or gifted from my parents, will shelter that money from a divorce action. The only thing which might be exposed is any appreciation or interest or dividend income, which the trust accumulated after it was set up, but the principal is going to be protected. So there are many different reasons that people utilize trusts, and they're not so horrible. Most people think of, oh, if I've got a trust, I've got to deal with the bank. No, I don't want to deal with the bank. Now, I'll tell you that some banks are very good, have wonderful trust departments. And also, maybe your son or your daughter is not good with investments.
Mm-hmm.
And the bank will invest these monies, and they have people on staff paid full time just to watch it. But on the other hand, there's nothing to say that you can't name your son, your daughter, your brother, your sister as trustee of the trust. You don't have to use an institution.
Mm-hmm.
Up to you.
Mm-hmm.
And you look at your family situation, oh, my son's very bright, but he's a brain surgeon. He hasn't got time to go to the toilet. He's not going to be able to manage these trust assets. So, I mean, you need to know what the roles are. I mean, excuse the joking, but the point is that these aren't earth-shattering things that you have to worry about.
Right.
You care and you understand what the consequences are and so on. Sometimes they say, oh, I'm going to make my eldest child the executor. And I say, whoa.
Right. Let's
Okay.
think
But
about it.
see, I'm putting everything into a trust. I'm putting like $300,000 into the trust, and I'll make my eldest child the trustee. And I say, is that going to cause any problems with his siblings?
Mm-hmm.
Is his sister going to grit her teeth every time she has to call her brother to ask for money from the trust? Okay. And maybe they have a great relationship and that'll be fine.
Right.
So, as I said, I just give them ideas, pros and cons. You know better than I do what's going to work for your family.
Right.
You just need to be given the tools to know how to craft this
Right.
family.
Yeah, I really can't imagine, from everything you're telling me, I can't imagine not using an attorney and trying to do it on my own in one way or the other, because the breadth of knowledge that the attorney would have is just it's overwhelming. It's so much more than I could possibly, unless I went to law school and studied. But even if you studied it, you don't have the experience of other clients having gone through that. And that is what I think is most valuable.
Yes.
If you've seen these scenarios play out, and you can study it and learn it, but living through it and helping others through it, I mean, that's a whole nother set of experience that you can only get from someone who's been through it. So, you've done it over 25 years, so I can't even imagine the number of stories. I think you should write a book at some point. That would definitely be a cautionary tale.
I do have plenty of stories.
I bet you do.
But I'll tell you, I was speaking with a surrogate in one of the large northern counties here in New Jersey. And, unfortunately, with this COVID and so on, they've been inundated with probating of estates. So many people passed away.
Yeah.
But I was shocked to learn, and this is a fairly wealthy county, that the great majority of the cases that they're handling have no wills. And so, you think a county that has this wealth and so on, that wouldn't happen. But it's, people feel mañana, I'll do it tomorrow, I'll get to it, or I don't really need it. Let me give you another case. Mother has only one child. She's divorced and she has one child, and she says, I don't need a will. Because I know the laws under the state.
Yeah.
The will, my heir is going to get it. And who's my heir? It's only my one son. So what do I need to pay an attorney to draw up a will? Well, what happened is she passed away. And in order to sell your house, in order to gain access to assets which may be in her name alone, you have to be officially appointed by the surrogate. That's what the probate process is. The will is presented to the surrogate. It says Esther Kane is named as executor, and you get appointed and you get a certificate so that you can then go and sell assets which were in the decedent's name. because you have in effect been put into their shoes. Well, in this particular case, the son had had college loans which he hadn't fully paid. And when there's no will, see, typically in most wills, we say, and again, I don't know what the online form says, it says you don't need to post a bond, okay? But if there's no will, you have to get an insurance company which says you won't run away with the assets and defraud the creditors or the other beneficiaries. And even though he was the only beneficiary, nevertheless, there are debts to be paid and so on, and they required him to post a bond. Well, you have to make an application, and he turned him down. They said, your credit is bad. You can't, we won't insure you. So the court had to appoint an administrator. That administrator gets paid, okay? So by the mother's not doing a will, it wound up the thousands of dollars of being paid to the administrator, whom she would not have selected. She wanted the son to act.
Right.
So there are many reasons why you should do a will. What a sigh.
It sounds like it. I know. It's just, I'm just imagining all these stories, and it just seems like a silly, I understand, because a lot of people don't, the complexity of it, and they don't want to go to the attorney. It's like, trying to convince somebody to go to the doctor, they don't necessarily always want to go. So, and I understand that. And then some people have the hesitation. They don't want to pay the attorney. They think it's some exorbitant amount or whatever. But I mean, from all these stories you're saying, your experience definitely shows that you end up spending so much more and wasting so much more by just not doing this one simple little thing. I mean, it's not little, but it's not the most difficult thing in the world either. You go to an attorney and they take care of it. They do the majority of the work.
Yes. Look, being an executor can be daunting. It does involve a lot of work, but that's why you have an attorney, to lean on them for advice, maybe some of the things they'll be able to handle for you and to guide you. The other thing is that it's a very emotional time. And I'm not just talking about a few weeks after someone has died.
Right.
It can be months and even years. So when you are distraught, it's not the best time to be dealing with paperwork and making financial decisions and so on. You want someone by your side who's going to be able to guide you.
Right.
And so that's the role of the attorney. And you're not paying for the document. You're paying for the advice.
Right, exactly.
That the attorney is providing you and the guidance. That's what you're really paying for. And he or she will know how to craft or design the document that it's going to fit your situation. We are not all alike.
Right, exactly.
We are very different. So,
well, I learned a lot. Now it makes me want to run and check my will and make sure I have everything in order that I need to have in there. Thank you so much, Mr. Bernstein. I appreciate it immensely. And if there was a take an attorney out to lunch day, I think I would have to do that.
I would love that, unfortunately. This is what it is.
Well, I look forward.
Thank you.
Oh, yeah. I look forward to the other interviews, on the other topics of, powers of attorney. I know I've been writing a few articles on that, and that is that's a plethora of information there as well. And then the health proxies, and of course the living wills or advance directives. You know, they call them all kinds of different things. And so I look forward to those interviews, but thank you.
Yes, and I'll just say in closing that a lot of people think, oh, if I have a will, that's the power of attorney. No,
It's
no.
not. I know, it's
The
not.
will only becomes effective when you die.
Mm-hmm.
Peter is not your agent under a power of attorney.
It's true. I mean, it's almost as if, you know, I wish that there was a handbook that we could get when we turn 20. You know, this is what, you know, you need as far as, you know, insurances and wills and all of that. I mean, obviously, I know that changes, you know, from year to year and state to state. But well, I did have one question. If
Sure.
you create a will while you're living in Florida, but you move to Colorado, do you need another will?
I'll give you an attorney answer. It depends.
Okay.
Typically, the states give full faith and credit to documents executed. If they were properly executed in Florida, New Jersey, for example, would recognize it. And matter of fact, just an hour before we spoke, I was dealing with a situation like that where a will was executed in Florida, and unfortunately, this person doesn't have the mental capacity to do a new will. And I looked at it, and it looks like it'll be perfectly valid here. But each state has their own requirements.
Okay.
So what I typically advise a client who is leaving New Jersey, the state, or New York, I say, wherever you're going, go see an estate planning attorney there and show them the documents, okay? Yes, you'll pay for the consultation, but they'll tell you, you know, this is fine, don't change it, or this document needs to be changed because.
Okay.
So the best thing is to find out.
Okay. Well, that's a good answer.
All right.
I wondered about that, so good answer. All right, Mr. Bernstein, thank you so much. I appreciate it very much.
Thank you for having me.
Oh, you're more than welcome.
All right. Bye.